lovely friends, good afternoon. Come and sit down with me and don't leave too soon. Thank you for stopping in, thanks for saying hi. Together we can make a difference if we try. Thanks for saying hi. Together we can make a difference if we try. Hello there, my lovely friends. Good afternoon. Come and sit down with me and don't leave too soon. Thank you for stopping in. Thanks for saying hi. Together we can make a difference if we try.
Hello everyone. Good morning, good afternoon, good evening, good night, wherever you are. Afternoon where I'm at. So that's why I played the afternoon intro. But thank you for dropping in, and thank you for your interest in London's case and getting justice for London. Hi, Ruby. Hi, Golden Rule. And especially thank you to my mods, Trace on the case and Ada K. Thank you so much for jumping in here to help mod. There's Amanda. And who else do we have in here? Hi, Amanda. Good evening to you. And to whoever else is watching. We're less than 3 weeks away now from London, or from Brayden Brown's next hearing, February 6th. So we still have quite a few things to go over. But if you paid attention to my thumbnail, you would have noticed that today we're going to talk about the other guy who was out running around with London and Brayden for a couple of days before she went missing. Well, after she went missing from home and was declared a runaway, but before she was last seen alive. So that is Jose Minjares-Luna. And we're going to talk about a little bit about him today. Hi, sis. You should have been a detective. Welcome in. Thank you for dropping in. So the February 6th hearing is going to be huge. Thank you, sis. I appreciate that. I'm going to look a little pale right now because I'm in a different studio. I'm not in my home studio. And so the lighting for my green screen has to be bright, and it's the same lighting that sheds light on me. So there's extra light on me today. But everything else I think is going good except for the lighting. Maybe I can fix that for the next time, because there will be a next time and then a next time before the February 6th hearing. I plan on two more live streams before the February 6th hearing, because there's a lot to talk about, and the February 6th hearing is huge. So tonight, we're going to go over Jose's criminal past and his court proceedings. And you're going to see a lot of familiar names that are going to come up again in Brayden Brown's hearings and Brayden Brown's court proceedings. Squeegee, hey, welcome in. Welcome in, buddy. Thank you for joining. So you're going to see a lot of familiar names, like identical names. The Honorable Judge Abby Cash is going to be, or has overseen hearings up to this point for Brayden Brown. The Honorable Judge John Parsley, his name appears on a couple of court documents as well. He's the head district judge. She's the associate district judge. And the Region 1 District Attorney, George Buddy Leach, his name appears in some documents. And the Assistant District Attorney, gosh, why did my mind just go blank? We'll see it. We'll see his name in a minute too. And his name, he's actually going to be the one handling the pretrial motions and the pretrial hearings, which is a pretty big deal because the February 6th hearing is going to be big. The February 6th hearing, the way that I understand it, is going to determine whether or not this actually goes to trial. Like the judge can review the witness testimony that comes before her and the evidence that comes before her, and she can decide, or he can decide. I don't know if it's going to be Judge Cash or Judge Parsley. Either one of them can decide that there's not enough evidence to proceed to trial. Trial TV Live, thank you. Welcome in. Very good to see you. Thank you for watching this update on London's case. So we're gonna get into the court documents. Jose Minjares-Luna is the one that picked London up from her grandmother's house on June the 5th and was out with her for 2 days before he gave his car keys to Brayden Brown to take London home from Guyman, Oklahoma to Hooker, Oklahoma. And of course, she never got home. And she was never seen alive by anybody other than Brayden Brown. And he's the one that has been charged with second-degree murder. Jose has never been charged with anything. He's a 20-year-old male that picked up a 16-year-old girl who was a couple of days later declared a runaway, stayed out with her, allegedly drank with her, or at least witnessed her drinking with Brayden and potentially doing drugs with Brayden. He has not been charged with anything. So let me just clarify that right off the bat. He's innocent until proven guilty, and he actually appeared in our comments on one of the early on videos. It was either the first one or the second one, declaring his innocence and saying that he gave his phone to the OSBI and the OSBI investigated him, and he has nothing to hang his head about. But I think the distinction may be made here that he had nothing to do with London's death, probably, according to the facts that we know in the probable cause affidavit and other witness testimony. But that doesn't mean he is not guilty of some serious crimes. And in fact, we're going to see in this first article that I'm going to bring up that the Hooker PD chief of police prepared a probable cause affidavit to file charges against him. So let me pull up that. It's a Woodward, Oklahoma is where Brayden Brown's mother lived and where Jose took London on that very first trip. Let's see, Woodward, Oklahoma. Here we go. This is the article that Woodward News wrote a couple of months ago. So I have to add to the stage. Here we go. Let's make it full screen so you guys can see it. Man charged in the death of 16-year-old found in rural Beaver County. So that's Brayden Brown. That's a picture of Brayden Brown, not Jose. But we're going to find out later. Brayden Brown has been charged with murder in the second degree, or in the alternative, murder in the first degree by misdemeanor manslaughter following the death of London. We already know all of this stuff. If you don't know it, Go back and see some of the earlier ones. The one that I want to point out here, the very last paragraph. This is Hooker PD Chief Scott Hedrick, who I also interviewed for an hour when I was out there a couple of months ago. Well, it's been more than a couple of months now, 3 or 4 months ago. Hooker PD Chief Scott Hedrick, who was initially in charge of the missing person investigation for London. I just did an arrest warrant for the other guy. I'm just waiting for the DA to see if charges will be filed, Hedrick said. I know that Jose Minjares does have ties to Mexico, and he came over to find out what happened to his car. So we're talking about, let's go over the timeline for a second here. She goes missing on June 5th. Well, she walks out of her house on June 5th. Jose picks her up, takes her to Woodward, which is where Brayden was staying with his mother that weekend. June 7th, Liz Taylor, that's London's grandmother, reports her missing, and she's declared a runaway. So that's Thursday, Friday, Saturday. On Sunday, Jose and Brayden reportedly went to Liz's house, knocked on the door, nobody was home. So they came back on the 10th. That's Monday the 10th, Monday, June 10th, 2025. They come back. Somebody is home then. Liz calls Chief Hedrick, says, these are the guys that were last seen with London. Get somebody over here. He sends one of his officers over, and he interviews, does a slight interview, gets a brief statement from Jose and Brayden. They don't call them in for an interrogation or an interview. They admit that they had seen London, like they were some of the last people to have seen London alive. They don't get called into the police. Later, Jose, who we're talking about today, does voluntarily come in for an interview with Chief Hedrick a day or two later. So that's the timeline we're talking about. Chief Hedrick says, I know there was a lot of evidence OSBI had to go through with forensics on the phones. We saw some of that on the PCA last time. We'll take a quick look at the PCA in a minute here. I knew there were going to be charges filed. That was against Brayden. I appreciate all her work from all the agencies working on this. Okay. So that's the article I want to start with Jose, and I want to do a little bit of a deeper dive into Jose. So next, let's take so Jose was involved in a crime in 2023 where he was initially charged with 9 counts. I think all 9 counts were felonies. Oh, no. Hold on, I got to get back on stage. There we go. I'm back on stage. Jose was charged in 2023 with 9, I think, felony counts. Most of them were felonies, if not all of them. And he ended up going to prison for a significant amount of time, but not nearly as long as his sentence was, before he was released on something that I don't understand the circumstances behind. But he was released in January of this year. And in April, we'll take a look at these court documents too. In April of this year, all but one of those 9 counts were dismissed or pled out. So he was ended up being found guilty by plea agreement to 1 charge, sentenced to 7 years, that was all deferred. That was in April, and he picks up London in June, less than 2 months later, or about 2 months later. So lots of funny things to check on here. Not so funny. Funny, not so funny. I mean, funny like curious. Let's go over his, so he actually spent time in prison. Let's go over his DOC record. Let's share that next. DOC. That's the offender search. There we go. That's what we want to see. And add that to the stage. So here is his Oklahoma DOC official offender page. We'll go into that real quick. They give his date of birth. So in 2023, he would have been just 18. So right when he turned 18 and became an adult is when he committed this. So here are the sentences that were handed down. Conspiracy, burglary, second degree, conspiracy, burglary, second degree, and conspiracy. We're going to see another court document later on that details these charges, and those are not the exact charges that are in the official court documents. So this is the online record of his DOC, but not all of these charges are accurate to what the court documents are. And some of those charges are concerning, especially as they relate to his relationship with London. So balance suspended. So conviction date 11/29/2023. Incarceration January 11th, 2024. So he actually spent barely a year in prison. 1288D, 1288D, 1288D. Conspiracy, burglary, and second degree, and conspiracy. Discharge date, look at this, January 2nd, 2025. So he spent less than a year in prison on these three charges. I don't know how that relates to how other prisoners are held in prison on these charges, but we're going to see other charges that are concerning. But he was released on January 2nd, 2025, according to the Oklahoma Department of Corrections. All right. Hi, Jenny. Good to see you. Yeah, that picture trace on the case, right. That look does not look like he's doing serious time in the state pen. Okay. So we'll go to the Oklahoma State court record now. This has some different charges than what we saw in his DOC record. It's probable cause affidavit. Here we go. Add this to the stage. Here are the counts from his 2023 case. Burglary in the first degree. Conspiracy, dismissed. Burglary in the second degree. Conspiracy. Possession of a firearm during commission of a felony. If you'll notice, there's no dismissed after that. That is the one count that he was eventually sentenced for, the 7 years deferred. Entering premises while masked, reckless conduct with a firearm, unlawfully wearing a mask or hood. That's an interesting law. Unlawfully wearing a mask or hood, petty larceny. So I haven't been able to find record of it, but what I've been told by locals is that he and probably Brayden Brown and maybe a third accomplice tried a masked armed robbery of a local grocery store. So that's probably why it's petty larceny, because there probably wasn't a whole lot in that cash register. Maybe a couple of $100. Probably less than 1,000, but definitely less than 5. I don't know what the definition of petty larceny is. But you'll see there's an extensive history of this file in here. Here we go. So it starts on June 21st, probable cause affidavit, June 21st, 2023, record of felony proceedings. So there are a whole lot of things that go on in this, starting June of 2023 all the way till, let's see, judgment and sentence as to counts 2, 3, and 4 only. So he pled out And counts 2, 3, and 4 were pled out for his prison sentence. And count 5, we'll see it. Let's take a look at the actual documents that go through them. We'll go through them in chronological order. If you're bored by court documents, I'm sorry. But I think these are important in establishing the foundation of, number one, whether or not Jose should be charged with anything related to London, but also the foundation of his history and him hanging out with her for a couple of days. So I'll close that out and we'll take a look at the actual documents. Here we go. Let's share. I'll share my PDFs, my PDF court documents there. That we'll do that. So we'll start with the part of the probable cause affidavit that relates directly to Jose, because he takes a prominent place in the probable cause affidavit. I mean, he was investigated very thoroughly by Special Agent Ryan Beck. And it's not just up to Special Agent Ryan Beck whether or not he should be charged. Obviously, Chief Scott Hedrick, Hooker PD Chief Scott Hedrick, thinks he should be charged with something because he prepared a probable cause affidavit for arrest for Jose. So, affidavit, we looked at this in part 2 pretty extensively. So I highlighted the part. Oh, and the highlights didn't save. Let's highlight those. Oh, no. I had this all ready to go and it didn't save. So recognize text in this file. Then we can highlight it much more accurately instead of just blobs. See, that only took like 5 seconds. This is the part I want to highlight. The investigation found that on June 5th, 2025, London left her residence in Hooker, Oklahoma with an adult male, Jose Minjares. Jose and LV drove to Woodward, Oklahoma, where they met with Brayden Brown. Interviews were conducted, and it was found that Jose, Brayden, and London spent the night in Woodward at the home of Brown's mother, Joanna Brown. While at the residence, Joanna witnessed Jose, Brayden, and LV drink alcohol and smoke marijuana. Joanna heard the three speak about meth. Jose believed that Brayden and LV ingested cocaine and meth while at Joanna's house. When Joanna went to work on June 6th, blah, blah, blah. We looked at that last time. Then they traveled to the home of Brayden's father. Here's another important part. Phone locations for Jose and Brayden showed that Jose, Brayden, and London drove to Guyman, Oklahoma, Perryton, Texas, and Beaver, Oklahoma from the 6th to the early morning hours of the 7th. So he was involved in this extensively. And despite the fact that he proclaimed his innocence, I mean, it seems like, according to the probable cause affidavit and to interviews that I've conducted and that I've heard from others, that he gave his keys to Brayden, and Brayden is the last one to be seen with London alive, and Jose didn't have anything to do with her actual death. So him proclaiming his innocence from that and wanting to clear his name from that, I understand and I get, because there's a big difference between second-degree murder and whatever other charges might be filed against him, if they can be filed against him. So we'll close that out. No, I don't want to save that. I should have saved it before. All right, so let's go back. Let's go back to 2023 before the masked armed robbery of that grocery store, allegedly, supposedly. Let's take a look at this petition for protective order in 2023. Heather Ann Marie Burns versus defendant Jose Minjares. Defendant's address. Oh my gosh. I didn't. Okay, I'm going to scroll up from that. I didn't redact that. I should have. But this is from the court, so they should have redacted it too. But I believe that that is the address, that is Jose's home address listed in other court documents. Defendant's relationship to the petitioner. Here's circles here. The defendant is otherwise related to me by marriage or blood. No. See, stalking. Defendant has committed the following acts against petitioner and or the minor listed above. Stalking instruction. Petitioner is a resident of the county wherein the petition is filed. Resident, legal stuff. All right, this is the interesting part right here. Description of the incident that happened on March 30th, 2023. So this is within a couple of months, if not sooner or shorter time period from the armed robbery, because the probable cause affidavit for the armed robbery was filed on June 21st, 2023, I think. And it usually takes them a couple of months to do an investigation into that thing, probably to get enough evidence to support a probable cause affidavit, even if it's just 1 month. I mean, so that would be May. So we're talking just a couple of months before the armed robbery. He backed into my yard when we were trying to get into my house, and he almost hit me with his car. He was 2 inches away from hitting me with the car while going fast. Jose entered my house. I felt threatened by him being in my house, pursuing Kylie. So that's her sister. And he was trying to drag her out of the house. I felt scared. I tried to help her 7 times. He contacted me at 12:39 a.m. and texted me, yo. And then at 1:48 a.m., he contacted me. I felt threatened by him contacting me, trying to get to Kylie. I was scared for Kylie. I don't have any other court documents related to this, so I don't know what the result of the petition for restraining order was. But that's a concerning narrative and description of his behavior. That's concerning behavior. Now, we don't have any evidence that he exhibited any of that type of violent behavior with London. We don't know. We haven't heard any of that, anything like that. But we're going to see a court document in this 2023 case when they set bail that's going to talk about why the bail was set at what it was set, that are indicative that what we just saw is probably related to his indicators for behavior. So this is the initial appearance in the 2023 case, armed masked robbery, allegedly. Well, it's not allegedly because, well, he pled out. We're going to find out that all but one of the plea deal was reversed and all but one charge was dropped. Initial appearance of the defendant. The defendant appeared personally. Defendant admitted his true name as charged. A judge competent for purposes of proceedings. All the legal stuff. Further proceedings as to attorney status set for June 28th. That's another interesting fact in this case. Who is his attorney? because we saw that Brayden Brown and his dad, who was charged in the misdemeanor case that Brayden and his dad had right before Brayden was arrested for second-degree murder, they were both judged indigent and were appointed indigent counsel. So public defender. Defendant was advised that if he was a minor, further proceedings as to attorney status, June 20th, 2023 at 10 a.m. Defendant's bail fixed at $200,000. That's a pretty high bail. That's pretty high, $200,000. Conditions on bond: no access to weapons of any kind, no contact with the state's endorsed witnesses. I don't have any documents that say who the state's endorsed witnesses are. No contact with co-defendants. So there are co-defendants in this case. Now, this will be the document that I think I was talking about, where we'll see some behavior patterns here. Courts required findings as to bail pursuant to Oklahoma state statutes. The court finds the defendant is charged with a violent crime. Evidence has been provided as to the following circumstances: defendant's history of domestic violence or a history of other violent acts. So that's not related to this masked armed robbery. This is a history of other violent acts or domestic violence. The defendant has a history of violating the orders of any court or government entity. The defendant is potentially a threat to any person. The defendant has access to deadly weapons or a history of using deadly weapons. That's history. That's not related to this case. That's prior to the armed masked robbery. The court has not heard evidence that a separation or termination of relationship between the defendant and victim has recently occurred or is pending. Other findings: defendant was in possession and use of weapons at a time when final protective order was outstanding. State's bond request: court sets bond at $200,000. Whew. So, oh yeah, Trace, we'll do that for sure. Let me star that. I got to take a breath here. There's a lot going on. There's a lot going on with Jose. Squeegee, yeah. And it's interesting you say kid, because we're going to find out that I think the judge cuts him a break, but I don't know for sure. The state, Olmsted Parker, that's the assistant DA. Olmsted Parker, he's also the assistant DA in Brayden Brown's upcoming hearings and potentially trial. George Buddy Leach, the head DA, is supposed to handle trial if and when it goes to trial. But you say kid, and he was legally an adult, so man, but it also sounds like while he was a kid, a minor, which is probably why we don't have court documents of it, that he probably was also not a good kid. Has issues. Takes them out on others, maybe, allegedly. All right, let's go to the next court document. Entry of appearance. This is an interesting one to me, because here we have 18-year-old Jose does not file for a public defender, has a private attorney from Oklahoma City, and Oklahoma City is not close to Beaver, Oklahoma, or Guyman, Oklahoma, wherever this hearing was. It's even further away from Guyman. Ryan Lowenstern is retained to defend him on July 5th, 2023. So a couple of weeks after he's arrested. So he doesn't file for indigent counsel. So I wonder if that means, because there are a lot of possibilities in my mind as to why he might not qualify, but I don't think he asked. I think in that initial appearance we saw, he didn't even ask for a public defender according to their record, but their record is really like, check this box, check this box, check this box, fill in this blank type of thing. So we don't know a lot of details, but it's curious to me that he or his parents or his dad have the money to hire a private attorney for 9 felony counts. That's not cheap. That retainer has got to be what, $20,000-$25,000, at least 10, but probably 20-25 just for the retainer. And in the end, the attorney fees are going to be what? So it gets even a little crazier to me. How can Jose afford a private attorney for 9 felony counts, which he wasn't convicted of all 9. I'm just saying, when you hire an attorney and you've been charged with 9 counts, you're hiring an attorney to defend you against 9 counts, and the attorney knows that, and they're going to charge you accordingly. All right, the next one. Oh, you guys didn't see that? Doggone it. No. 620 bonds. Here we go. I pulled it back up. Look at me. Now we're going to do this. There you go. Now you can see his private attorney. Brian K. Lowenstern represented him throughout from July 5th, 2023 on to his final sentencing in April of this year. Obviously a private attorney, not a public defender. Now in Indiana, in small counties like Carroll County, as we saw in the Richard Allen case, private attorneys become public defenders because they get put on a list, because in small counties they can't afford to hire public defenders. But in Oklahoma, they have a statewide public defender system. So that's what was appointed for Brayden Brown, but not a private attorney like this for Jose. Yeah, look at me. I found that real fast. All right. Next, document record of proceedings in open court, felony. Preliminary inquiry and assignment as to a guilty plea. The defendant, so this is in November 29th, 2023. This is his guilty plea. This is the date of his guilty plea. So he's charged with 9 counts. Defendant appears in open court. Defendant appears with attorney Ryan Lowenstern, who we just saw, affirmatively waived the 2-judge rule. And I don't believe that Brayden Brown has waived that 2-judge rule, which is why we're seeing Judge Cash right now, and we'll eventually see Judge Parsley. Legal stuff. Now down to the highlights. Yay, this one saved my highlights. The defendant entered a plea of guilty to the following counts: 2, 3, and 4. Counts 1, 6, 7, 8, and 9 were dismissed with costs. So that's part of the plea deal. We will plead to counts 2, 3, and 4, and the prosecution will dismiss 1, 6, 7, 8, and 9. Affirmatively waived his constitutional rights. That's, to me, a pretty big deal. You waive your right to an appeal. I think, though, you can appeal on the basis of incompetent legal counsel or ineffective counsel. But we're going to see an appeal of sorts on a different of a different sort in January of this year that I don't fully understand yet. And I Googled it and I still don't fully understand it. And maybe we can talk about it together. Defendant advised the court that he understood the minimum and maximum penalties of the charge. The defendant advised the court that his guilty plea was made voluntarily. The defendant waives his right, and the state of Oklahoma waives the right to a PSIR, post-sentencing investigation recommendation, I think. Judgment and sentence. It is the judgment of this court. Let's highlight that. Boom. It is the judgment of this court that the defendant is adjudged guilty and is sentenced to the following. Count 2, 10 years. Department of Corrections, all suspended upon successful, don't mess that up, completion of the Bill Johnson program. So somebody from Oklahoma that's familiar with the Bill Johnson program is going to have to explain it to me. I know that Liz Taylor, that's London's grandma, is familiar with it, is very familiar with it, and I'm not sure that I understand it yet after she explained it to me months ago. 7 years Department of Corrections, all suspended upon successful completion of the Bill Johnson program. Count 4, 10 years, all suspended upon successful completion of the Bill Johnson program. Counts 2, 3, and 4 to run concurrent with each other. So there's a Bill Johnson program. He's sentenced to 10, 7, 10, 27 years on 3 counts, with 4 counts being eliminated, being pled out. And all 27 years are going to be suspended upon completion of the Bill Johnson program. I need to know what that is. Because we saw in the bail document that he has a violent, and he has a history of domestic violence, and he has a history of using firearms. I mean, he has a history, and we're going to sentence him to 27 years, and he's going to go through a program. So I want to know a lot about that program. Winnie, you'll have to, if you know that's a substance abuse program, then I want to know about it. But for somebody who has a violent past, I want it to be more than a substance abuse program. Like, you can't, I mean, can you blame domestic violence on substance abuse? There are probably maybe isolated incidents where people would excuse that, but a history of it, I don't know. I don't know, Winnie. I need to know more. I need to know more about this program. I need to know more. First-time nonviolent offenders? Trace, what? Center is a dedicated... Wow, that text box is really big. You can't see me. Let's go back to this then. Center is a dedicated substance abuse cognitive behavior program facility for felony drug offenders. These weren't drug offenses. This was based on masked armed robbery and first-time nonviolent offenders. This isn't a nonviolent offense. Make it make sense. The Bill Johnson program. Winnie, yeah, yes. It is due to lack of facilities in our area. I get that, and I've heard that, and I've seen that. Oklahoma suffers from a lack of true rehab facilities for teenagers and adults. But if you have a history of violence and you commit another violent offense, do you really qualify for that type of a program? Liz and Brittany and Rochelle are going to have to fill me in on that. I'm not familiar with the Bill Johnson program. It doesn't make sense. Make it make sense. All right, let's go on to the next document in Jose's history. All right. So here is a record of felony proceedings before. So he pled guilty in November and was put in that Bill Johnson program in late November of 2023. So here we are a little over a year later. But it said, it said he was incarcerated in his DOC file, I think, on January 11th. So he was sentenced to that in November, but he didn't have to report to the DOC until like a week and a half into January of 2024. So he goes in early January 2024 into the DOC. And there there's Parker Olmsted, ADA. We've seen his name, and we'll see his name some more in Brayden Brown's case. January 22nd, 2025. So a little over a year after Jose reports to the DOC and enters that Bill Johnson program, whatever it is. January 22nd, 2025, defendant appeared personally and with his attorney, Ryan Lowenstern, same guy that signed on July 5th of 2023. Still there. Defendant, a judge competent. Record is FTR. That's for the record. That's the court's cameras and microphones. Matter is continued to February 7th at 1:30. Arrange CNS and MTN to vacate pleas 2, 3, and 4. So there is a motion. MTN is motion to vacate pleas 2, 3, and 4. So there was a motion filed, and that's not in the court records. I could not find that in the court records. The motion to vacate pleas 2, 3, and 4. And we'll see the reason, or not the reason behind it, but the legal concept behind the motion to vacate pleas 2, 3, and 4. And this is going to be it was a surprise to me, and hopefully it'll be a surprise to you. But the motion to vacate pleas 2, 3, and 4 weren't just filed by the defense. They were also filed by the state. The state filed motions to vacate the pleas to 2, 3, and 4. The defendant's bail is fixed at PR bond. I don't know for a fact, but it's my understanding because the DOC released him on January 2nd, PR bond means personal recognizance. That's like ROR, released on your own recognizance. I believe PR bond is personal recognizance bond. I believe he's out of prison and he is out of custody in early January of this year. And if and when we talk to Brittany again, if she's willing to talk about it, how that timing may be related to London's behavior patterns starting in early 2025 and leading up to her ultimate death. All right, so this is the continued date, February 18th, 2025. Record of felony proceedings before the examining magistrate, February 18th, 2025. The hearing for February 19th, 2025 has been continued to March 12th at 1:30 p.m. due to inclement weather. The bond is continued, which I believe to be the personal recognizance bond, and signed by Abby Lukash, the Honorable Judge Abby Lukash. It's funny because I read all these court documents before I interviewed Hooker PD Chief Scott Hedrick, and I said, and he mentioned Judge Abby Cash, and I was like, does she go by Abby Lukash? He's like, not that I know of, but that's what it says on her signature right there. It says Abby Lukash. Isn't that what you read? All right. That's that document. So here we are in March. So the the January hearing schedules a February hearing, which gets continued to March. So here we are, March 12th of 2025, March, April, May, June. This is literally exactly 3 months before London's body was found outside of Forgan, Oklahoma. Exactly 3 months. The timing of this is just so disturbing. Comes now the state of Oklahoma. Okay, so the defendant filed a motion to withdraw the plea out of time. Okay, let's look at that real quick. Let's do scan OCR so I can highlight some things in here. Recognize text in this file. All right. So motion to withdraw plea out of time. This is the state's motion to withdraw the plea out of time. I could not find the defendant's motion to withdraw plea out of time. So we're going to have to take clues from the response to the defendant's motion. Statement of facts. On November 29, 2023, that was the sentencing date for Jose. The defendant entered into an agreement with the state and pled to the following. The state agreed to dismiss counts 1, 6, 7, 8, and 9. The defendant pled guilty to counts 2, 3, and 4. I would have said guilty. They left it out, leaving count 5 outstanding. So count 5 has not been decided yet, but they agreed on 8 of the other 9 counts. Count 5 was set off to prevent any issues with defendants' admittance to the Bill Johnson program. Still don't understand that. The state concurs with the movant's statement that the latter part of the agreement was outside of the plea paperwork. Make this make sense to me, somebody. The state concurs with the movement statement that the latter part of the agreement was outside of the plea paperwork and that the parties would jointly move to vacate the counts addressed in the previous plea and allow the defendant to plea per agreement on count 5 only. I don't know what's going on here. I need an attorney to explain this to me. The state concurs with the movement statement. The latter part of the agreement was outside of the plea paperwork and that the parties would jointly move to vacate the counts addressed in the paper. This doesn't make sense. So this is, let's look at the signature down here. Parker Olmstead, Assistant DA. He's handling a lot of the pretrial preliminary stuff with Brayden Brown. And I'm reading between the lines here that he may not know what he's doing. Like if he's the one that wrote the plea agreement and agreed to the plea agreement and there's something improper with the plea agreement, he may not know what he's doing. Parker, you're welcome to correct me. You're welcome to set the record straight and tell me what's going on here. Allow the defendant plea. Oh, okay, Trace. Oh, okay. Okay, got you. That makes sense. They withdrew some of the counts so he could qualify for the Bill Johnson program. Oh, that would make sense. But it doesn't make sense because he has a violent history. He has a history of using firearms. So why is the state agreeing to that? Was their case that weak? Like, we got to do better for London, guys. On Brayden Brown's case, we got to do better. We can't be having mistakes like this. On January 22nd, the parties attempted to execute the agreement to completion since the defendant had been released from prison, having successfully completed the Bill Johnson program. I'm reading the paragraph 2 here. This court in turn requested the parties to present briefs demonstrating the court's legal authority to vacate the pleas and that a diligent effort should be made to contact the victims. So the court's saying, I don't know that I have legal authority to vacate the pleas. And a diligent effort should be made to contact the victims. I like that. I like that from this judge. Is this Judge Abby Cash? There's no signature there. It's just Parker Olmsted. Yeah, a diligent effort should be made to contact the victims. Agreed. Like, there are victims, and if you vacate the plea deal and you just charge them with 1 out of 9 counts, is that justice for the victim? There's a whole bunch of legalese here. Notwithstanding any other provision of law concerning post-conviction relief, a district attorney in the jurisdiction in which a person was convicted of an offense may file a motion in the district court to vacate or set aside a judgment of conviction at any time if clear and convincing evidence exists establishing that the defendant was convicted of an offense the defendant did not commit. I don't think that's the case here. I don't think that's the case here. I think there's good evidence that Jose did what he did. I mean, maybe there were a couple of those lesser counts that there isn't clear and convincing evidence, like unlawful wearing of a hood or mask. That the parties are not seeking to have a hearing as to whether there is clear and convincing evidence exists. Okay, to my point, that the defendant did or did not commit some or all of the crimes. The parties have jointly agreed that the state shall motion to vacate the previous plea. So he's contradicting himself. Assistant DA Parker Olmsted is contradicting himself. He's citing Oklahoma State Statute 22 OS 1381. A district attorney may file a motion to vacate or set aside if clear and convincing evidence exists. And in the next paragraph, he says, we are not seeking to have a hearing as to whether there is clear and convincing evidence that the defendant did or did not commit some or all of the crimes. So he's like contradicting his own citation of Oklahoma statute. Dude. And we'll see in a minute here that the judge sees through that too. And this is my first time reading it. And I just, furthermore, state supports and concurs with the movement statement. I don't care if you support, and I do care, because is that justice for the victims? Let's look at that right there. Furthermore, the state supports and concurs with the movement's statement. I haven't ever heard movement before. Isn't it like petitioner or defense counsel or something? Movement statement that if the court should ultimately find the aforementioned statute inapplicable, the only other statutory vehicle for the defendant is a motion to withdraw his plea as he has filed. In turn, the state would agree there is compelling reason to grant the motion out of time. There is the key word that I'm still trying to figure out. Like, motion out of time due to the defendant's reliance on the original plea agreement. Grant the motion out of time. So when I Googled out of time and a plea agreement being reversed for out of time, that means one party or the other did not comply with the terms of the plea agreement in the time required to do so. So if he had a year to complete the Bill Johnson program and he didn't do that, then the plea agreement gets taken back and he has to face those charges again, or has to reach a new plea deal and do it all over again. But here we're seeing they're trying to reverse the plea agreement in his favor. And we're going to see that in a minute in court documents. So apparently the state didn't do something in a timely fashion as a part of the plea agreement. What did they have to do in a timely fashion to comply with the plea agreement? Like, what is out of time for the state? Yeah, Jenny, I agree. If the program is for nonviolent offenders and they drop violent offenses from the counts charged just to let people in, that seems a little unjust. All right. That's it for that document. All right, here is a court minute. So the matter comes on for motion to withdraw a plea and motion to vacate sentencing before the Honorable Abby M. Cash, Associate District Judge. Plaintiff present by ADA Parker Olmsted and the defendant with attorney Ryan Lowenstern. The record is made by the FTR. The defendant present with attorney Ryan Lowenstern, state present by Parker Olmsted. So this is interesting to me because the February 6th hearing that's upcoming is probably going to go similar to this, because there have been two parties subpoenaed to present witness testimony. And I don't know how much evidence, actual like forensic evidence, might be presented. I think it's just going to be testimony on February 6th. So this continues. The court takes testimony and hears argument of counsel as to outstanding oral motion to vacate sentence. That's why there's not a document for it, because it was an oral motion to vacate sentence and the defendant's motion to withdraw pleas out of time. Both parties urged the court to vacate the judgment entered on counts 2, 3, and 4. Both parties, the state and the defense, urged the court to vacate the judgment. In the alternative, the parties urged the court to allow the defendant to withdraw his previously entered pleas of guilty on counts 2, 3, and 4. After hearing sworn testimony, argument of counsel, and reviewing the pleadings and relevant legal authority, the court finds there is no legal authority to allow the court to vacate the previously imposed sentences in counts 2, 3, and 4. The court finds there is no legal authority to allow the court to vacate the previously. So the court doesn't have the authority to do it. As such, the court denies the oral motion to vacate the sentence. The court, however, grants the defendant's motion to withdraw pleas out of time. So she read Parker Olmsted's contradictory argument, and she's like, dude, you didn't convince me that I have the authority to do it. However, I'm granting the defendant's motion to withdraw pleas out of time. I want to see that document. I want to see that plea, that motion for withdrawing the pleas out of time, finding that it is in the best interest of justice, as the pleas were entered upon advice of counsel pursuant to an agreement in good faith between the parties. Where has bad faith been shown after that? The court orders Mr. Lowenstern, that's Jose's attorney, to prepare J.E., not sure what that is. Defendant is ordered to appear before the Honorable Judge John K. Parsley for arraignment on counts 2, 3, and 4, and 5 on April 8th, 2025 at 10 o'clock. PR bond, personal recognizance bond, continued to that date and time. I don't understand what's going on. I need to see some more documents, and they're not all available on the OSCN. I think that if you hire a private attorney, you probably have a pretty good chance of like a better outcome in your case. Well, we know that. We know that across the board. I mean, public defenders have their hands full. They're overworked, understaffed, underpaid. But private attorneys are not underpaid. They're paid very well. So I don't know. I would like to know. I'm curious who is paying Mr. Lowenstern's bills. All right. So now we go to April 2nd, 2025. Although it says now on the 12th day of March, 2025, this is about the state's oral motion to vacate the plea. The court has previously requested the parties. So oral motion to vacate the plea means that Parker Olmsted stood in front of Judge Cash and said, hey, we'd like to withdraw the plea out of time, which is what the defendant's motion was. It is hereby ordered the state's motion to vacate the plea is denied due to lack of statutory authority. It is further ordered the defendant's motion to withdraw a plea out of time is granted in the best interest of justice. The court finds that counts 1, 6, 7, 8, and 9 were all dismissed at the original plea of November 29, 2023, and count 5 was set off for formal arraignment. Court finds that the plea entered on counts 2, 3, and 4 is withdrawn in the best interest of justice, and that counts 2, 3, 4, and 5 shall be set before the Honorable Judge John Parsley for formal arraignment. So out of the 9 counts, 2, 3, 4, and 5 are left on the table after this date, after April 2nd, 2025. And both attorneys signed it. Judge Cash signed it. So we have sentencing to go to. There's one more document that is about the plea agreement. I think we'll see the facts of that shown in the sentencing document, which we have coming up next. All right, sentencing, April 8th. So this is May, June. This is exactly 2 months. Well, 2 months short of 3 days. 3 days short of 2 months before London went missing. This is Jose's sentencing for his 2023 case where he served about a year in prison and then had his plea agreement revoked and all but 3 sentences, or all but 4 counts dismissed by the court. Record of proceedings in open court, felony, April 8th, 2025. State of Oklahoma, present by Parker Olmsted. Record made by Mario Blander. Defendant appears in court in person. Defendant appears with attorney Ryan K. Lowenstern. Defendant admitted his true name, advised the court he could read and write, speak in Spanish, all the legal stuff. Waived his right to 24 hours in which to plead. Defendant entered a plea of guilty to the following count 5. Counts 2, 3, and 4 dismissed with costs, and he affirmatively waived his constitutional rights. 2, 3, and 4 being dismissed are part of the re-plea deal. So Parker Olmsted and Buddy Leach agreed to drop 3 of the remaining 4 counts for him to plead guilty to count 5. He advised the court he understands the minimum and maximum times or penalties made voluntarily, waives the right, in the state of Oklahoma waives the right to a pre-sentencing investigative report. Defendant waives his right to 48 hours on judgment and sentence and waives his right to judgment and sentence within 30 days. Judgment and sentence deferred to April 8th, which is today on this document. Oh no, judgment and sentence. Hold on. I misread that the first time through when I read this. Hold on. Let me get back down to where we were. Check that out. Judgment and sentence set deferred to April 8th, 2032 at 11:45 a.m. What? Judgment and sentence set deferred to April 8th, 2032. That's not just he got a sentence. Yeah, it was. Okay, let's keep on reading. Defendant informed by the court of the nature of the information, his plea, and asked by the court whether he has any legal cause to show why judgment should not be pronounced against him. Defendant replied in the negative and no cause appearing to the court. It is the judgment of this court that the defendant is adjudged guilty and is sentenced to the following: count 5, 7 years, deferred to April 8, 2032 at 11:45 a.m. plus court cost. Defendant ordered to pay restitution as per RC probation court. Counts 2, 3, and 4 dismissed with cost. Court's usual rules apply. Defendant is ordered placed under supervision of the DOC and is ordered to pay a monthly probation fee to the DOC. Defendant notified of his right to appeal to the Court of Criminal Appeals. Previous bond is exonerated, and the defendant granted personal recognizance. I knew that's what PR stood for. Personal recognizance bond as to fines and costs hearing. Defendant to remain in the Beaver County Jail for 10 days before being delivered to the DOC. Not applicable. He's not going to the DOC. He's not being held in the Beaver County Jail. Oy vey. Somebody make it make sense. Somebody make that make sense. So, we've been going for a little over an hour now. Do we want to take a ride into Hooker and through Hooker to see where, I don't know exactly where Jose picked up London, but to see what Hooker looks like and what it might have looked like when he did pick her up? Obviously, he's not pulling up in front of Grandma's house to pick her up. He's going to park a block or two away, and she's going to walk a block or two away and get in the car. And then they head to Woodward to meet with Brayden. Let me see if I can find that. We'll go to Google Earth first. Let's take a look at Google Earth. You know I love Google Earth. Boop, boop. Add to stage. Let's maximize that. Let's reduce that menu on the left. And we'll go to Hooker, Oklahoma. So I stayed up in Liberal. That's got like hotels and stuff to stay up there. Hooker does not. I mean, they have the Hooker Inn on the north end of town, but yeah, that's probably not an option. All right. So that tag is actually like right on the police department. So let's do a little path. So when I come into town, I come in from the north up here. And then I think I drive, oops, gosh darn it. I forgot you can't scroll while you're doing a path. So I won't go all the way outside of town. So come in from the north side of town and then drive all the way through town down to here. That's not working out. You guys probably can't see that real well either. Style color. Let's make the width like 3. 2.5. That should work. So come in from the north end of town. And drive through town on US 54. And then I think I came down here by the little power substation, did a little U-turn, drove back this way. And then I was looking for the police station. So I come up here. I didn't Google map it at first. I ended up having to Google map it. And then I drive through the little downtown area, and it's actually kind of a cute little downtown area. And then drive this way, down this road, then over to the post office. And I pulled over and I'm like, I can't find the police station. I'm going to Google map it. So I Google mapped it right there. And then, of course, I turn around from the post office and I drive the wrong way. So I do a U-turn and I come back here. Then I park right across from the police station. So that's that one. That's the first video. Then the second one, let's see, I'm going to have to zoom out a little bit. See how it's triangular, like Hooker is off at, is that like a 45-degree angle from due north, due east, due west? All right. So I start at the police station for the second one. Boom, right here. And then I go up past the school. So there's the school. She actually didn't go to school there. I believe that she was doing an online school thing. So then I come around here. And then I go back down past the high school. And then up here. And then, let's see, back down to this road. And I heard some Mexican music playing. And then I found the Mexican restaurant. And I went the other way. And ended up back down at the railroad tracks. So we have 2 videos to watch. Boop, boop, boop. Give me 1 second to load them up here. Where did all my tabs go? My tabs disappeared. I just got them uploaded to YouTube right before the show. So I'll probably add them as members only videos for a while, just so you guys can take your own tours if you want. I think it's a little bit better than Google Earth. It's a little less chunky and it's a little more like boots on the ground, right? How do I play this? Expand. Play. There we go. We got it going. Here we go. Hooker for the food. Actually, I got a recommendation for where to eat in Hooker. I never did, though. I never did. I'm always in any town for the food. Here we go. It's not playing. It's not playing. That's great. That's awesome. Let me go to, let me see if I can go to my channel and see if I can, because I'm playing it from studio right now, but I wonder, videos, wonder if I can play it from my videos instead. It's not in my videos. Please be patient with me while I try and figure this out. Where did it go? I have no videos. No. I got to check on my other laptop and see what happened to it. Let's go with that. Let's try that. No, it's not there either. This is so weird. Let's see if I go to Dropbox. Wonder if I can play like the actual video itself. Last time I tried to do that though, it didn't play the audio of it, so I'm leery about it. We may have to save it till next time. I'm going to give it one more shot. And if this doesn't work, then we'll save it for next time. I'll take you boots on the ground inside of Hooker, Oklahoma. Yeah, that's me signing into my own account. And all right. It's not going to work today, guys. I got to work on that for next time. We'll go boots on the ground. I'll show you Hooker as I drive in from the north and go through on US 54, which I'd been through a couple of times before. But once you cross the railroad tracks to the northwest and you go through downtown and you go past the police station and then you go the other way past the high school, you get a totally different feel for Hooker, and I did. So let's do that in the next part. I'll make sure that I've got it set up and ready to go. Thank you, everybody, so much for joining me for this. Let's remember the February 6th hearing is going to be huge. It really makes me nervous that you have the same judge and the same ADA that did what we just saw with Jose overseeing Brayden Brown's hearing. And when Brittany and Rochelle come on and talk about the last hearing, there's some other concerning things too. Like you guys were saying, it's a small town good old boy system, and we have to overcome that to see justice for London. So we have to keep this in the public eye, keep everybody's attention on it. June. Good question, and I doubt it. Everything so far has been on the FTR, and it's going to take some pressure on the judge to air it publicly. But if we can get it done, we'll get it done. And we definitely want to put a lot of pressure once we get to trial for the trial itself to be aired. And also knowing that Chief Scott Hedrick did an arrest warrant for Jose and the prosecutor hasn't acted on that yet is something that we need to keep an eye on too. Because I think we can all agree, even though he may not have been directly involved with her death, there was a lot that went on leading up to that he was involved with. And obviously it's up to the prosecutor to figure out what those charges should be, but it's hard to believe there can't be any, especially since the chief of police did an arrest warrant. We'll see, Trace. We'll see. I don't want to get kicked out of court. Thank you, everybody. Thank you, mods. Thank you, Trace. Thank you, Ada. Thank you, June. Thank you, Angela Turtle Mom. Thank you, everybody, for joining me in chat and to watch this and look. Oh, wait, I had one question I have started to ask. Trace on the case. Pay tribute to our little Arizona girl found on the res. Let me see. Malika Molly Boone, 8, has been found dead on the Navajo Nation Reservation in Arizona 1 day after she disappeared while playing outside. The child was last seen near Cedar Loop in the coal mine NHA housing area. They did a search for her and they found her. So let's have thoughts and prayers for her family, for peace, and also justice for her, because the circumstances of that sound like they're, yeah, we're going to have to talk about that more later too. But we definitely can't forget about all of the victims out there and a little 8-year-old girl on the Navajo reservation. They often get overlooked. I mean, just like London laying out there for 5 days and not being found for 5 days. And that affected the investigation, that she wasn't found for that long. At least they did a good search and they found Molly Boone within a day or so, but not a good happy ending for her. So we'll keep an eye on that case, Trace. Thank you for filling us in on that. We'll get into more details. And yeah, let's pay tribute to her. But also keep our eye on this February 6th date and getting justice for London. Everybody take care. Have a great rest of your Sunday. And we will talk to you on the next London update in the near future.
See you soon, my lovely friends. Have a good afternoon. Don't forget to stop back by and see me real soon. Thank you for stopping in. Thanks for saying hi. Together we can make a difference if we try. For stopping in, thanks for saying hi. Together we can make a difference if we try. Thank you for stopping in. Thanks for saying hi. Together we can make a difference.